page 10 of the bill.
Right. So I don't think any tweaking would be necessary because what would be put in 3.2 about being in accordance would impact this section. So it would have to be in accordance with 3.2.
So any taking into custody of the child would have to be, the child would have to be treated in accordance with the provisions of the Child Care and Protection Act. All right. Any comments from members?
And
Member
Chairman,
Charles?
for
Yes.
section 3.3, I think we were concerned about where it says subject to subsection 4, where a parent or guardian of a child consents to be surety for the child for the purposes of this section, that the parent or guardian may or shall. What did we decide on? May or shall?
May.
Okay.
Yes. All right. Any comment from members who are in the virtual space?
I have a note here that it should be
Shall?
shall, yeah. I'm not sure if that was a decision, but I have a note that it should be shall.
It's a kind of a may where, let me ask the CPC for her perspective.
Yes, well, this would be leaving it to the discretion of the decision maker in respect of bail, whether they're going to require the parent or guardian to ensure that the child complies with the conditions. If it shall, well, then it would remove that discretion entirely, which is a policy issue.
When you read 4, so it appears that once you consent, you really would be required to ensure compliance by the child. And the only time that you would get out of that is where the child will attain the age of majority before the time appointed for surrendering to custody.
If that's the case, then what's in 3, the may, should really be a shall.
Yes.
Madam Chair,
Yes.
I want to support the position that it should be shall,
Yes.
for the very reason that, as we are discussing, it's a child.
Yes.
And the obligation must necessarily be on the parent
Yes.
to ensure that the child complies with the directions
It
and the
stands to
conditions of
reason.
bail.
I think it stands to reason. I think it stands to reason, especially with the subsequent provision of when the burden would be lifted from the parent. But yes, I agree with you, Senator Scott Motley. Thank you for raising it, Member Charles. All right, so I will just make a note that clause 3, subclause 2 is to be reworded to reflect that the Bail Act does apply, but that the deciding authority would be the Children's Court. The Bail Act would apply, but where bail is denied, the child is to be treated in accordance with the Child Care and Protection Act, provisions of the Act. Right. All right, we can then skip over to, the one remaining matter. The LRD was to do a little research to see where we would set the penalty in respect of the offense for tampering with or destroying or whatever the format would be.
Yes, Chair. Ms. Simon conducted research. I'll allow her to share her findings.
All right.
Okay, so what I found was that there were actually that a lot of jurisdictions still don't make express provision for electronic monitoring. Amongst those that do, there are two approaches that we observed in our research. One being to simply punish it treat with it as you would the breach of any other bail condition, which would involve issuing a warrant for bringing the person in. The other approach, which we saw only in the Cayman Islands, was to make it an offense for tampering, and the person would be punished liable to a fine of $500 and to imprisonment for a year.
So we would then consider that research against the policy approach in the bill of how we deal with failure to comply with a condition that is imposed.
Because the concern would be that this person could potentially go beyond where the authorities are not able to monitor them as they are required to be monitored. Yes. So that is perhaps the reason why most jurisdictions treat it as a breach of a condition of bail, revoke the bail, and bring them in.
Right. Right. And I think that is the approach we have taken in this law in respect of conditions of bail. But I think the other question arises because the device actually is a device that is put on to the person with a cost that is attached to such a device. So I think we can just give it a little more thought in addition to treating it as we do other conditions for internal policy coherence and consistency, but also to consider further, which I think is a point that was made in addition to what it means when you would have tampered with this kind of device. Bear in mind that the condition one can only be judicially imposed. And that is done to strike a balance along many lines. So if at the end of the day you can geofence and properly monitor, you don't want to keep the person in custody. And it's going to be important that the authorities are able to monitor the movements of such a person. And if you tamper with it, which means that you are making it either difficult or impossible for the monitoring to be done, and then also rendering the device useless or damaged, then we have to consider what consequence would flow from that. All right, so thank you, Team LRD. We will consider further. Any comment from members of the committee? All right, if we have none, let us pick up where we left off on page 27 of the matrix. Ms. Wilkins, please.
Yes, Chair. This is clause 11,
Yes.
Review of bail decisions, Jamaicans for Justice. It is being suggested to amend section 11.3 as follows. A judge of the court concerned shall, at least once per week, carry out a review of cases involving defendants who were granted bail in relation to offenses to be tried before that court, but were unable to take up such bail, and for the purposes of this subsection, a list of those defendants should be supplied to the court on Monday of each week.
The provision says a judge of the court concerned shall, at least once every 2 weeks, carry out a review of cases involving defendants who were granted bail in relation to offenses to be tried before that court, but who were unable to take up the bail. So they're saying, don't do it fortnightly, do it weekly. Well, all decisions really have regard to a number of things. So it's whether it... I like to use the term, the administrative ease with which things can be properly done. And sometimes when we speak of administrative ease, we do not consider the practicality of it. And I'll use, for example, us sitting here every day with the committee clerk, and records of the meeting, minutes of the meeting are to be provided. And if you sit all day in the court, in the parliament, and you expect that at the end of the day, every day, meaning the frequency with which you impose a duty, that it is to be carried out, it sometimes, even with the best of will, becomes burdensome and impractical. And I think many times when we are imposing duties, we do not seem to sufficiently consider realistically what can be done without it becoming unhelpfully laborious. So it was really from that perspective that the time frame was set. We also seem to forget that based on the statistics provided by the judiciary, our courts have a whole lot of cases. And in an effort to get through those cases, judges sometimes sit long hours in the court. I throw the matter out for consideration. I think it says at least doesn't mean that it can't be done more frequently, but it is really saying that 2 weeks shouldn't pass without the review being done. So I don't see any harm in how it is worded, because the time frame is not so far away. But I invite comments from committee members.
Sir, I think the framing is entirely appropriate. As you have pointed out, it does not, it suggests a minimum.
Yes.
It doesn't say that it can't be done more frequently,
right.
But I'm particularly sensitive to the workload that I see that the judiciary sometimes has.
Yes.
And one has to be fair to everybody, not, to the accused as well as the judges. Yes. And so you can't set realistic targets for them when they don't have the support and don't have the infrastructure which will necessarily facilitate their carrying it out. I take into account the fact that now a lot of things are done remotely, and that might assist. But I still think that the provision is satisfactory. I don't support the recommendation which has been made.
Yes. Any contrary view? Anything to be added? Madam CPC?
No, just that it also concerns the earlier point that was made about the frequency of the sittings of the courts. But then I was looking at it and bearing in mind the remark that Senator Scott Motley just made about things being conducted remotely. I think the assumption was made that these reviews were being done in court when the court is sitting, but I thought that the purpose of assigning it to a judge was to allow for that review process to take place continuously, not necessarily in a home court sitting. So the point about the frequency of the sittings of the courts then would not apply. So that need not be addressed. But then also I would also agree with the point about the workload.
Yes. Yes, I really I'm a little disappointed that in accordance with the provisions of the law, we didn't receive a comment from the Court Administration Division about just the sittings and arrangement and the scheduling. I really am disappointed. When you don't consult, you hear, you're criticized, and when you try to consult because the law provides that it can be done, and you get an unhelpful response, is a little disappointing. But yes, thank you. So we can indicate, unless anyone else has another view, that this recommendation is not accepted by the committee. Okay. Yes?
Norma Manley Law School. There is a lack of clarity in the appeals process for matters covered both by Section 10.3 and 11. Section 11 matters are a subset of Section 10 matters, and therefore a defendant with such a Section 11 matter has access to the court under both Sections 10 and 11. Furthermore, it appears that the review court also has simultaneously the power to hear a renewed application under Section 9.3. Inconsistent listing of the powers of the judge / deciding official in Sections 10.1. This does not include affirm. Section 10.3. This does not include confirm / affirm or revoke. Section 11.4. This includes affirm in contrast to Section 10.3 and Section 12.7. This includes affirm but does not include
Didn't we
revoke.
Consider this provision last time?
I think we did.
Yes,
we did.
yes. I think we had.
I think they put it twice.
Oh, I see.
Because the comment refers to both.
To it in 10 as
Sorry,
10.
I can't hear both of you at the same time.
Oh, sorry, I was just pointing out it is included on the previous page in relation to clause 10.
I see, yes, because I'm seeing a note that we did consider this provision. All right. And we had spent some time looking at it in the last meeting. Right. All right, so we can move on.
Yes, okay.
Which would take us to clause 12 now.
Well, there's a recommendation.
I think we had considered that too.
Is that the same? Let's see. I think this recommendation is different. The Section 11 matters have 3 conditions precedent required for a review. The application for review must be done by the court having jurisdiction to try the offense. It must be done on the first appearance of the defendant before that court, and the applicant must fulfill a condition under 11.2. The submission is that the review process serves very little utility and can readily be excluded without loss to the provisions.
Well, that was not the policy intent. Was to enable a quick review, especially non-contentious matters. So you may have a condition for bail that you would like to have reviewed, and it can be done easily without actually going through the appeals process. So 11.3 says, it's the same provision about the time. A judge of the court concerned shall, at least once every 2 weeks, carry out a review of cases involving defendants who were granted bail in relation to offenses to be tried by that court, but who were unable to take up such bail, and for the purposes of this subsection, a list of those defendants shall be supplied to the court on the Monday of each week. All right, before I go into that. So what the section is providing for is that defendants who have been granted bail but have not taken up the bail, those matters are to be reviewed by the judge. You think we're going to hear a question arising about how do we interpret judge of the court concerned? I think one raised that. And I had asked Madam CPC if there was any other way of stating it, because sometimes what is clear to us may not be so clear even to persons who are trained as we are. And then the rest of it, we specified on whom the responsibility is placed to supply the list. So if the defendant is held in a lockup, the police officer in charge of the lockup has the duty to supply the list. If the defendant is held in a correction institution, and this is as defined in the Corrections Act, then the individual in charge of the institution would have responsibility. This specification is to ensure that there is no doubt as to on whom the duty is placed to supply the list of the persons to the court. And then on review, the power of the judge is to affirm the decision reviewed, grant or refuse bail to the defendant, impose conditions on bail granted to the defendant, or remove or vary conditions. That, to my mind, seems clear, but it may be unclear. And in the case of a review, under subsection 1, that is where. So, Madam CPC, subsection 1, okay. In case of a review, the judge may revoke bail granted to the defendant, or where subsection 5.4 applies, shall make such order as the court considers appropriate. So let's see what clause, be reminded what clause 5.4 say. 5.4 speaks to the defendant who is on bail before the charge has been laid, and who may apply may make an application there. All right. So the Norman Manley Law School is saying that the submission is that the review process serves very little utility. I am not inclined to agree with that, but let me hear from other members of the committee. All right. All right. So the scheme of the law is to provide not only for appeals but for review in the first instance. If there is no contrary view, then this recommendation is not accepted. And we can.
Chair, just if we're dealing with a situation where an individual was granted bail but was unable to take up the bail for whatever reason.
That's a review, not an appeal.
Agreed.
Yes.
But on what basis then would you be refusing the bail when you review it? I'm thinking
On an application?
I would think it would more be that you already granted it to them. So I'm thinking it would be a change in the conditions that you would consider rather than grant or refuse, because this follows on a review of persons who had already been granted but were unable to take it out.
So that's only, the powers relate to the entire section, not just subsection 3. And I think that is why that power is given to the court. Because you may find in an appropriate case, it would be for the court to determine bail is granted out of court, and for whatever reason, upon the matter first coming before the court and the judge doing a review, depending on the circumstances that may change between the time when bail was granted out of court and the matter coming before court, the interest of justice may require revocation of the bail, and I think that is why the power is there. It happens now in practice. It is what the interest of justice would require in accordance with the standards specified. That is why that power was included. It's not just dealing with review under 11.3 of persons, of defendants who were granted bail but are still in custody not having taken up the bail. It speaks to reviewing a decision that was made. This is an out-of-court bail now, because the constable or the JP would be granting bail out of court. Station bail is really what it is. All right. So we can move to clause 12.
Yes, Chair. Appeal from decision of judge. And this is Jamaicans for Justice. For section 12.1, a defendant being unjustly denied bail that is later overturned on appeal should have clear knowledge of the remedies available to him to mitigate the damage this previous incorrect decision may have caused. JFJ recommends an insertion in section 12 indicating such an avenue. 12.1c, where a defendant previously denied bail is successful in appeal under subsection 7, that defendant may bring an action in the civil court jurisdiction of Jamaica to claim damages for any loss suffered in the period of detention.
Throw it over to Mr. Foreman of the Chambers to help the committee respond.
Chairman, on this one, I'd prefer to hear from the committee first. It's largely a policy question in the first instance.
Can you imagine if everyone taken in custody on reasonable suspicion were to have a civil remedy against the state? It would turn the entire system inside out. But the state, jurisprudence does allow for a determination to be made on whether the basis for arrest or detention, that threshold was properly met. It is in those circumstances. But a mere denial of bail where someone is properly taken into custody, I think sometimes it is not sufficiently understood as we're seeking to strike the right balance, that we're talking about limited taxpayers' money to deal with matters. The state is not supposed to be, the necessary connections are not being made. The law does not allow, simply because there is an acquittal, that you would have actions flow without more and without defined circumstances. You're about to say, Mr. Foreman?
Right. I would only add that I think the comment is coming from a place of concern in the context of, let's say, a deciding official who, perhaps maliciously or otherwise exercises his discretion in a way to deny bail, and that decision is later overturned. But there are various circumstances in which an appeal might be allowed. Circumstances might have changed, or you may just simply have had a different official comes to a different assessment of the factual situation. And in a situation like that, it might not be appropriate to invite the kind of action that's contemplated.
But the law
here.
is not without a remedy in this case for any proper wrong that has been done, whether at common law or otherwise. Such a person is not without remedy. Yes. Any comment from committee members?
Madam Chair, I'll make it very clear that I could never support that. There are circumstances in which the action of the deciding official smacks of malice and other elements creep into the decision, and there is recourse available.
Exactly.
But to accept this recommendation would definitely turn the judicial system on its head. It would create a Pandora's box. And whereas I understand where it comes from, what motivates the recommendation, I do not think it is wise.
In a proper case, such an aggrieved person is not without remedy in a proper case.
Absolutely.
Right.
That is very clear.
Yes.
It has been well litigated.
Yes. All right. We need not spend so much time on it. We can say that the committee has not accepted this recommendation. All right. We can move on. Yes.
Norma Manley Law School. Section 12 provides for appeals at all the different levels. However, certain terms are used inconsistently. It is also suggested that there should be some inclusion of the term revoke the grant of bail and impose conditions of bail in Section 7. Inconsistent listing of the powers of the judge, deciding official. Oh no, sorry, I went to the wrong direction. No, it's the same thing being repeated concerning Section 10.3 and Section 11 in relation to the use of the word affirm. That concern is repeated in relation to Section 12.7.
The use of the term affirming a decision on appeal is a known term in our law. On appeal, a decision being appealed against can be affirmed. And in such a case, it means that the appeal is denied. So that is known in appellate parlance.
So it's properly referred to in 12.
Yes.
But I'm not sure why 10.3 continues to be cited, because 10.3 is a recording of the decision, not a provision for review or appeal.
10 speaks to the kind of decisions the reference to decisions that are made, but it really is speaking that when decisions are made in any of the many circumstances, the decision is to be recorded and you must give information.
So, exactly.
Yes.
So affirm is not an issue in 10.3, so I'm not sure why it continues to be looked at.
Right, because one of the issues that we're addressing with the provision to ensure that the decisions are recorded in prescribed form and that the information about the decision is given to the person is a general complaint of people not being able to get or get in a timely way decisions from the court. And of course, other institutions not under consideration here. And so that is why Clause 10 is there. It merely sets out the kind of circumstances in which decisions are made. But it is really providing that once you make decision in any of those circumstances, you shall, in the prescribed form, make a record of the decision, and you shall cause a copy of it to be given. And we use cause a copy because it's not the judge or deciding official that will do the actual giving of it, right? But the administrative officers, the clerks, etc. And that's why it's causing a copy of the record to be given and given on both sides of the matter.
The only solution would be to not list the decisions and just generally provide for whatever decision arrived at being recorded. That is the only it's the only thing that could possibly be considered.
And then you may hear the concern that it really is not meant, it's not so much a decision, etc., and it's not. So I don't see the harm done in specifying, because the first one speaks to matters that the defendant needs to know. The grant or refusal of the bail, there is a duty to surrender to custody, and in terms of conditions imposed, because if you fail to abide by the conditions imposed, that has consequences. If bail has been revoked, that has consequences too, because a person may appeal a decision to revoke the bail. So I am not appreciating what is a real concern that is raised through these comments. Madam CPC, you detect any issue?
No, Madam Chair, we had agreed on certain changes last week, which I think address all the concerns.
Very well. If we have no comment from other committee members, we can proceed to the next provision.
And just to note that, having regard to what CPC just said, an amendment to 11.7 was agreed to add revoke. 12.7, I beg your pardon, to add revoke.
Yes, I have that noted.
Okay. Appeal, okay, this is still Norman Manley Law School. In section 12.3b, the 72 hours given to the prosecution represents an unreasonable encroachment on the liberty of the defendant. Whether by the use of technology or legislation, the Crown has already addressed their mind to issues and does not require 72 hours within which to file their appeal. The increase from 24 hours to 72 hours is an unreasonable encroachment that can and should be minimized.
This, you would recall that this time frame was set based on the data provided to us, the information provided to us by the Office of the DPP, and it becomes extremely it's if you're out on circuit, for example, between a Friday and a Monday, is really to take into account, practically speaking, that time frame. People don't get back into office to get the administrative support when you're in court very long on a Friday. And that really is the time frame. Right? If it can be done earlier, then it should be done earlier. But if we don't have regard to what is practical to getting the work done, you know, we sometimes confuse due process and taking steps with unnecessary bureaucracy. But it is going to be extremely important for us to understand what action steps flow from decisions. I throw it out for comments from members. And within doesn't mean that you can't do it earlier. The encouragement always is where an outer band is set, as far as practicable and where possible, that the decisions are taken sooner than later.
Chairman, I agree with you. I don't think we should accept this recommendation. It has to be workable.
Any other comment? All right, if we have none, then we can say the committee is not accepting the recommendation. Next.
Clause 13. Norma Manley Law School. It is submitted that the retention of the present Section 13 under the Act is a fairer option. Section 13 has attenuated the powers of the court in general by listing a schedule of offenses which are excluded from the court's discretion to grant bail at this stage. Furthermore, the inclusion of the term immediately in the provision further restricts the categories of persons who can apply for bail. In addition, the section has also removed the right of appealing the refusal of the parish court judge to grant bail on an application before her. Instead, the bill gives an either-or option. An applicant who is convicted before the parish court must choose between making an application before the parish court judge or making an application to the Court of Appeal. The creation of the schedule, in particular, has moved a range of offenses outside of the discretion of the court. The defendant who falls under Part 2 of the second schedule is barred from making an application even if they satisfy the test at Section 13.2 of exceptional circumstances, warranting being granted bail pending their appeal. They're suggesting the existing 13 be retained. Yes, but we didn't have
Clause 13 deals with bail after conviction. And this is where the person is convicted. And it speaks to where the person was out of custody on bail prior to conviction. And it speaks to certain types of offenses. So what this section is saying is that there is no power of appeal being given generally after you have been convicted. No power of appeal in respect of bail. It's not being given generally after you've been convicted, because what follows from a conviction is sentencing. But it creates a category. So if you are convicted of an offense other than the serious offenses listed in Part 2 of the second schedule, and if you were on bail before you were convicted, And if you appeal the conviction, you may apply to the judge before whom you were convicted or to a judge of the Court of Appeal for bail pending the determination of the appeal. The option is given to the two courts are given jurisdiction for ease. Wherever it is more convenient, it can be done. And on an application, I think we had indicated that the word appeal should be changed to application. Under one, the judge may grant the application if satisfied that exceptional circumstances warrant and impose conditions on the grant of bail as the judge considered. It's truly an exception to allow for a defendant to be on bail after conviction. It is an exception. So Ms. Wilkins, you want to help us better understand before I throw it to the committee what?
There really is not a lot of difference between the existing 13 and the bill, except that in the existing, there's no schedule, yes. So the delineation of different categories of offenses didn't arise before. And the basis on which the appeal can be granted wasn't set out in the existing law. So it didn't have to be that the judge had to be satisfied that exceptional circumstances warranted the grant. Or I think in the case of the Court of Appeal, we probably shouldn't restrict the basis on which the Court of Appeal grants bail. What we have now is they may appeal to the Court of Appeal if they're appealing the refusal by the parish court judge, and maybe that should continue to be the case. So the Court of Appeal.
So let us just look on the schedule, the offences in Part 2, because this is a policy matter to inform the legislation. With the new Firearms Prohibition, Restriction and Regulations Act, which distinguishes firearms and ammunition that are illicitly trafficked and that are not recorded and in the system, we're saying that if you have been convicted of those offenses, first of all, you shouldn't be on bail pre-conviction, but once you're convicted, these are matters which carry custodial sentence only. The murder, those matters on the prohibition side of the new firearms law, and the matters relating to the gangs. And then the matters where we have special security operations on the ground in the Zozo in respect of identity. But a question had been raised about the treatment of that offense, which we are considering and will come back. And the other has to do with the lotto scamming, the fraudulent transaction law. So those really are they. And the data we have is that these categories of offending are particularly egregious in the society around that. So there is a reason why it is not at large now that we are reforming the bail law, because we're having regard to what is happening in the society. So at the time when the 2000 law was passed, these matters of the illegal gun running, the lotto scamming, and the gangsterism may not have featured as prominently as they now feature. So that is the explanation in respect of those offenses, if you're convicted for those offenses. Right. And as a matter of policy, we're saying that once you are convicted, it's really only in the most exceptional circumstances that a grant of bail should come, because after that, you're to face your sentence. If you are not liable to a custodial sentence, the issue does not arise because you would not be in custody. Comment from any members?
I want to make it clear that I don't support this this decision. Last week I spoke to, for example, the inclusion of the offense under Section 21 of the Law Reform Zones of Special Operations Act for failing to disclose identity. You explained to me that it was the very basis of bringing a criminal charge. I disagreed because, as I said, that in Jamaica you have to take into account the culture of the society. I am of the view that the judge should be given the discretion that if satisfied that exceptional circumstances so warrant, he can grant bail after conviction and impose such conditions as he considers appropriate. And I don't see why we should have the deliberate exclusion, which we do now, of those listed in Part 2 of the second schedule. I think that the approach which every judge has used is to take these matters into account. But I think that the fact that you are allowed to consider exceptional circumstances is very important. We cannot here as legislators decide what could arise that would make a judge feel that in those circumstances, and only in those circumstances, bail should be granted. And I cannot understand why the policy would be to remove that discretion from the judiciary. I want it placed on record that I do not support it.
So
I agree with you that bail after conviction, the starting point is that bail after conviction is unusual. So there must be already existing exceptional circumstances for a judge to consider and deal favorably with that application.
And your position makes no room for the illicit gun running and the stockpiling and all of that? Those
absolutely
matters.
Because there is no judge who, having regard especially to the policy of the government, who would not take that into account. But I am saying, Madam Chair, that if there are exceptional circumstances which arise subsequent to that conviction, or indeed are inherent in the conviction, why shouldn't the judge be allowed to consider that regardless of the offense for which a person is convicted? I don't see the basis and the logic. It suggests to me that there is no confidence in a judge's ability to discern the circumstances which are appropriate in granting bail after a conviction.
I wouldn't consider it as a lack of confidence, but I would instead say that it is a clear indication of the policy intent behind the provision. But I think other comments came on the provision. May I just ask that we just look at other comments that came? I recall other persons commented on this, and then we can just do a comparison between what we have here and what exists. So your stance is duly noted, Member Scott Motley. Let's just hear what other persons said.
Just my last comment on that, Chair, is that there's quite a body of law that already, jurisprudence already exists surrounding the grant of bail after conviction by the Court of Appeal. So I don't know. I think, and remember, these are not the offenses in the second schedule. So I'm still saying, should we stipulate that they must be satisfied of the exceptional circumstances? And so I just wondered if it shouldn't just say that maybe, that the application can be brought and leave it there, as it is in the existing law. But I'll move on. Having said that. Clause 14.
Hold on.
Sorry.
So this was the only comment in respect of the bail after conviction. I thought we had some comments from the individuals, at least.
Oh, I think. Oh, I'm
Jared.
sorry. I forget that we have two.
Yes.
Yes. My apologies.
Yes. My recollection is that other comments came in on this provision.
Or in general recommendations. I'm just locating it, Chair, just a second. There were general recommendations, but there's no specific 13. Let me see. Page 2. So yes, so it's in general recommendations by Jordan Jarrett.
Yes.
The following are being proposed on post-conviction bail. Post-conviction bail should be available in appeals against sentence, even if in very limited circumstances. The inclusion of the exceptional circumstances threshold for post-conviction bail is welcomed. There should be no limitation on the type of offenses that qualify for post-conviction bail. Rationale. The source of the Court of Appeal's power to grant bail after conviction, otherwise called bail pending appeal, is the combination of the Judicature Appellate Jurisdiction Act and bail legislation. Outside the powers granted by those enactments, the Court of Appeal has no inherent power to grant bail. Careful attention must therefore be paid to the provisions surrounding the grant of bail after conviction, as they entirely circumscribe the Court of Appeal's jurisdiction to grant bail. The need for care in the crafting of provisions related to bail pending appeal is emphasized by the fact that several courts have held that deficiencies in a comprehensive legislative scheme can negatively impact the enjoyment of fundamental rights and give rise to successful claims for constitutional relief.
So that comment is doing one of two things: welcoming that threshold of exceptional, well, more than one thing. Rightly recognizes that there is no inherent jurisdiction in the appellate court in respect of grant of bail after conviction. And the jurisdiction is statutorily given. And when statutorily given, the jurisdiction is limited to what is provided for. So if the law says that you can't give it for certain offenses, then that is the jurisdiction of the court. You can only consider it for all of the other. Both Senators Scott Motley, as a member of the committee, and Mr. Jarrett, as a stakeholder who presented to the committee saying that we should not circumscribe, we shouldn't accept any offense in granting this jurisdiction to the court. All right, I will give some further thought to it. I'm not at liberty to take policy decisions on my own in respect of this matter. I think I certainly understand the point made earlier by Senator Scott Motley around the offense of identity, especially given how it is treated. And you get a good glimpse of the seriousness with which conduct is viewed if it becomes an offense by the punishment ascribed. And right now, the punishment is at a low level. So it does beg the question, why would the failure to disclose your identity be treated so seriously when, if convicted, the penalty is low? That really needs to be thought out. But I would ask that the position stated by Member Scott Motley in respect of her views on this be reflected in the minutes, and I will come back to this provision from a policy perspective in light of the other comments made. All right?
Proceed, Chair.
Yes.
Clause 14. The Jamaica Bar Association. In Section 14, it is recommended that Parliament must consider on its own whether the expansive nature of the proposed amendments in the Act, pre-charge bail in brackets, requires the passage of a special Act of Parliament pursuant to Section 49 and 50 of the Constitution, as is necessary for laws which abrogate, abridge, or infringe constitutional rights.
So let me just pause right there to say that the application of Section 49 is in respect of the matters specified in 49.
Mm-hmm.
Right? And there is a difference between amending the constitutional provision and actually amending a law relating to that. Mr. Foreman, curiously, can you pull up Section 50? Member Scott Motley, this is an issue that we're
50
dealing
has
with.
Been repealed. That's the provision.
I know that.
Oh,
this is a matter that we are dealing with in the Constitutional Reform Committee.
No,
Can
I
you
think
just,
this is a comment on Clause 5.
yes, but can you just pull up the old Section 50 for me of the Constitution?
You mean
And may I just crave committee's indulgence? I just need to step away for 1 minute. While you pull up, just excuse me for 1 minute.
Chair,
Have you found
how do you
Section
like me
50?
to proceed? Yes.
Okay, one moment.
Would you like me to read it? So this is the pre-charter.
Use your mic, please. I'm not hearing
Oh, sorry. So this is the old Section 50 of the Constitution, which is now repealed. was repealed when the Charter of Rights came into effect. It says, an Act of Parliament to which this section refers shall not be void to the extent of any inconsistency with the provisions of sections 13 to 26 inclusive of this Constitution, but shall, notwithstanding such inconsistency, prevail over those provisions. And subsection 2, an Act of Parliament to which this section refers is one, the bill for which has been passed by both houses, and at the final vote thereon in each house has been supported by the votes of not less than 2/3 of all members of that house.
May I just ask you to read again, please?
Yes. So the old section 50, an Act of Parliament to which this section refers shall not be void to the extent of any inconsistency with the provisions of sections 13 to 26 inclusive of this Constitution, but shall, notwithstanding such inconsistency, prevail over those provisions. Subsection 2, an Act of Parliament to which this section refers is one, the bill for which has been passed by both houses, and at the final vote thereon in each house has been supported by the votes of not less than 2/3 of all the members of that house.
Thank you, Mr. Foreman. Please read again.
Constitution from first year Constitution.
Please read again, Ms. Wilkins.
From the beginning, Chair?
Yes,
Okay.
for 14.
In section 14, it is recommended that Parliament must consider on its own whether the expansive nature of the proposed amendments in the Act, pre-charge bail in brackets, requires the passage of a special Act of Parliament pursuant to sections 49 and 50 of the Constitution, as is necessary for laws which abrogate, abridge, or infringe constitutional rights, including the special majority prescribed that is not less than 2/3 of all members of each house voting. And its Ringer Marshall Burnett judgment is cited.
So that comment displays not knowing that Section 50 has been repealed from the Jamaica Bar Association. All right? Yes, proceed.
No, we're trying to understand the comment in relation to clause 14, and I think we're agreed that it is here because clause 14 applies to both pre-charge bail and post-charge bail, and the comment is in relation to a person who is on pre-charge bail who has not been charged or arrested for an offense, who has not been charged or convicted of an offense, whether they should be at any liberty of being convicted for absconding bail.
So we
because their freedom would not have been...
Right, so that is premised on a view that it is a charge that determines whether or not you should be detained. I think Mr. Foreman's presentation last week clarified that it is not whether you are charged or not charged that the exception is provided for. It's whether there is reasonable suspicion that you have committed an offense. That's the threshold. Person. So what I find is that there is a thinking that a charge places you, the defendant, in a different position in respect of the deprivation of your liberty. When you look on the case law, it doesn't quite say so. What a charge does is to, if I were to use a comparison from another area of the law, almost operate as a crystallization. And once a charge has been made, time flows in a different way. Because after you've been charged, you're expected to be tried within a reasonable time. And we have a whole set of case law. But all of the provisions, and I think more than anything else, the Chambers' presentation last week should provide some clarity around that, especially with the case laws cited, that it is not so much the charge, but it's whether there is reasonable suspicion that you have committed an offense that would allow for the deprivation of liberty. Am I getting it correctly, Mr. Foreman? Can't hear you off the mic.
Sorry, that's a fair description.
Yes. All right, so proceed.
Should I read the rationale?
Yes.
Section 14(1) to 3 deals with someone who is arrested or detained and outlines the fundamental rights and provisions in those instances. And I believe this is meant to be the Constitution and not Clause 14. Subsection 4, however, for the first and only time in the Constitution, deals with bail, and it says, any person awaiting trial and detained in custody shall be entitled to bail on reasonable conditions unless sufficient cause is shown for keeping him in custody. Section 14(4) of the Constitution notes that any person awaiting trial and detained in custody shall be entitled to bail on reasonable conditions unless sufficient cause is shown for keeping him in custody. Obviously, one cannot be awaiting trial unless one is charged. Our Constitution, in short, does not contemplate or allow for bail conditions to be imposed prior to charges being laid.
Right. I think if the guidance provided by the Chambers is accepted by the committee, then some of the concerns raised here would have been addressed. Mr. Foreman?
Yes, Chair, and I suspect that when we get back to Clause 5,
yes.
We can have some more discussions.
Yes. Any comment from members of the committee? It just shows how a number of things, we're not always all sufficiently au fait with the amendments made. Section 50, I have a curious view around the repeal of Section 50 in the absence of a referendum in relation to Section 2. This is a matter that has stayed with me for a long time.
No comment on that one from my side. So.
Well, you are in the Constitutional and Legislative Affairs Division of the Chambers, and you do tutor in constitutional law. We are not, when we make our comments, we are not making judicial pronouncements on them. But if you look on the guidance coming out of the same case that is cited, the Independence Jamaica Council for Human Rights and Syringa Marshall Burnett and the Attorney General, what it makes clear is that you can't look on the sections in isolation from other sections and the impact, because you may amend something and it has implication for another provision. So an attempt at repealing Section 50, which is an ordinarily entrenched provision, does not stand on its own, because a deeply entrenched provision references Section 50. And if you repeal it, then you would, as the CPC would tell you, would need to take out the reference to the repealed section, because that's how you properly tidy up your law. And then when you look at 49, which I mean, 49 is so curious. It tells you that what alter means. It includes amend, modify, reenact with or without amendment or modification, make different provision in lieu of, suspend, repeal, or add to. So to modify, to take out the reference to 50, which is repealed, would require a certain process to amend, because
Chair, a note of caution here.
Yes.
50 is linked to the Charter of Fundamental Rights and Freedoms, and it was deemed inimical to that charter to retain 50. But if you question the process used to remove 50, we are in danger of questioning the process used to insert the charter. So I'm just saying, it's a bigger question than just removing 50,
but 50,
whether there should have been a referendum.
50, no, I'm not speaking to the insertion. My understanding, my very limited understanding of it, is that you don't need a referendum to amend the provisions that are ordinarily entrenched. And the rights provision of the Constitution are ordinarily entrenched. But procedural matters around, two important procedural matters for the constitutional amendment are deeply entrenched provisions. That's 49. And I think 50 would have become somewhat deeply entrenched because of its connection to the constitutional supremacy provision at 2. I am going to defer to the scholars. The real question is, can you repeal Section 50 that is referenced in Section 2 and then take out the reference to Section 50 without holding a referendum having regard to Section 49? That's $1 million question, you know. But that's for another place.
Well, I'm sure that, Madam Chair, since you wear two hats, when the Constitutional Reform Committee comes to consider it, you will take your place very clearly.
That's what
and as you say, we will have scholars.
Yes, that's what I was referring to. But, you know, some things only become clearer along the way with a little more knowledge and a little deeper research. The Constitution is not a document that people live in the same way that you may live other provisions of the law. There are some hidden jewels in the Constitution that people don't even know exist in the Constitution. Or you hear questions raised or statements made, and the answer is clearly provided for by an explicit provision there. But this section.
Well, at the end of the day, I hope that after we go through this process, people will find the hidden jewels. That we will make everything clear.
And hide them. And they no longer remain hidden jewels. But let me just ask Mr. Foreman briefly, is that provision, the old 50, meant to be the parliamentary supremacy clause in respect of rights procedurally, that if you pass them a certain way? I've seen it described in some literature as such.
I wouldn't adopt that language primarily because in our system we view the Constitution itself as being the supreme provision, and try to make a distinction between the UK system where Parliament is supreme and the system introduced with a written constitution.
When you look at 2 making it subject to 49 and that provision, making it subject to the process by which you amend the Constitution itself?
Right. I would say that what Section 2 does is to say that the provisions of the Constitution must be followed, and that the only exception to that are the matters provided for in Section 49 regarding an amendment to provisions of the Constitution, or Section 50 as it then was, regarding the Parliament's ability to pass a law that is inconsistent with the then fundamental rights provisions in the pre-charter Constitution. So the old Section 50, I would say, is similar to clauses that we see in the Trinidad and Tobago Constitution, the Canadian Constitution. They call it the notwithstanding clause, that allows Parliament to enact legislation that is inconsistent with the Bill of Rights, and to have that legislation continue to stand, notwithstanding the inconsistency. So I would say that was the purpose of Section 50. In the Constitutional Commission report that recommended the repeal of Section 50, my recollection of the discussion was that it was felt that the existing procedures for amending Chapter 3 would be sufficient to enable Parliament to enact legislation would be sufficient to achieve the purpose that Section 50 sought to do. That is to say, to introduce legislation that created an exception to the Bill of Rights provisions. So Section 50 has the same procedure that applies to the amendment of the Bill of Rights. So there's an extent to which there hasn't been that fundamental a change by virtue of the repeal. The one difference, I suppose, is that the old Section 50 applied to specific legislation, whereas if one wants to create an exception to an existing right in the Charter, you'd have to carve out that specific exception in the text itself, rather than maintaining the text but having an ordinary law that remains lawful notwithstanding the inconsistency. I suppose those are the broad comments I'm prepared to make.
Well, we're not bound by the
50.
comments in this stage, because the recommendation is not a recommendation for consideration by this committee. But since we also simultaneously have another committee that is providing guidance for the review of the Constitution, this recommendation will have it noted for that forum. Because this committee is not dealing with an amendment to the Constitution, and these recommendations are suggesting amendments to sections 14 of the Constitution.
Right. I think what they're trying to say is that the basis of the Bar Association comments concluded that the pre-charge regime is not consistent with the Constitution. Right. So they were saying, if you want this thing to be lawful, you have to amend.
Right. Right.
So it was in that context the statement was made.
The Bar has taken a narrow literalistic view of the reading of the provision, which the case law that I've looked at say that's not the approach to take when you're interpreting rights provision of a constitution. But so I would say that unless there is any dissenting view, that this recommendation wouldn't be accepted for reason that this committee is not reviewing an amendment to the Constitution, but I'll certainly note it. And I think Senator Scott Motley, who's also a member of the Constitutional Reform Committee, would be noting it when we come to dealing with those provisions. All right.
There's a recommendation to amend Clause 14.4.
Yes.
A person who commits an offense under subsection 1 shall be liable on A, summary conviction before a parish court to imprisonment for a term not exceeding 2 years or a fine not exceeding $500,000. The bill presently has a term of imprisonment not exceeding 5 years. B, conviction before a circuit court to imprisonment for a term not exceeding 5 years or a fine not exceeding $700,000.
So you would recall...
We don't have provision for a fine.
You would recall that this matter, we deliberated on it quite a bit with the assistance of the Office of the DPP on having dual jurisdiction to deal with matters of absconding bail, especially in relation to defendants who are before the circuit court, and the convenience that it would be not only for prosecution but also for a defendant to have those matters dealt with. I recall vividly the senior deputy director of public prosecution saying that there were files pile high that would cover him with the number of cases, including involving defendants who have absconded. And it is because of how absconding is being treated in the scheme of the law why it is no longer punishable with a fine. I wanted to, before we jumped on, Madam CPC, did you have any comment that you would want us to consider in relation to the previous matter?
In relation to the question of Section 50?
Yes.
Not necessarily, but I only think that the whole question concerning Section 2 and the effect thereon is whether the reference there is merely incidental to or fundamental to the operation of that section, to me, would determine how it could have been treated with.
Yeah, so it's, like I say, it's a matter that I've had keen interest in. And because the provision speaks to inconsistency and inconsistency being null and void with the Constitution, it's more than, it's more deeper, a deeper reference. But we'll deal with it in the other forum. Let's come back.
Chair, I need to point out that when I turned the page, I was actually reading Jamaicans for Justice, and their proposal for amendment is in relation to persons convicted of absconding in the case of pre-charge bail. So it was a provision they were seeking to have put in respect of pre-charge bail, not for post-charge.
The proposal to amend Section
14.4. So there was a
5.
There was a part that went before it, which I ought to have read. So let me read the precursor.
It's not a bad recommendation, actually.
Yes.
I think from JFJ on that matter. But let's read on.
Okay, so the precursor to the proposal for amendment is, it is being proposed to amend Section 14 or Section 5 to include a section dealing specially with absconding on pre-charge bail. A person who is released on pre-charge bail commits an offense, this is a proposal, if that person, A, fails to surrender to custody, or B, having reasonable excuse for failing to surrender to custody, fails to surrender to custody as soon as possible after the time originally appointed for the defendant to surrender to custody. 2, a person who commits an offense under subsection 1 shall be liable on summary conviction before a parish court to a fine not exceeding $100,000 or to imprisonment for a term not exceeding 3 months. Okay.
Adam CPC.
I was just wondering the rationale for distinction, because is it any less egregious for you to have absconded on bail if the fact that it was pre-charged rather than after you were charged, I would think the whole principle concerns the fact of the absconding while you were on bail and not your position in the criminal proceedings at the time.
Right. So when I said it wasn't a bad suggestion, I was merely referring to perhaps specifying it in relation to pre-charge bail, but I do share your view. Are you raising your hand, Mr. Foreman?
Yes, I mean, only to say that in relation to the pre-charge regime, there are other submissions that recommended, creating a distinction between the wrongness of doing something in relation to pre-charge regime versus the other regime, premised, as I understand the submissions, on the idea that the person who's not yet charged is in a less perilous, a less serious position than the person for whom the authorities have concluded that there's enough evidence to charge them. So this is one of a series of recommendations seeking to soften the pre-charge regime. So that it's another one of those things that when we get back to clause 5, we may have another discussion about it there.
Right. So we have two sets of provisions, two sets of recommendation. One set saying pre-charge can be accommodated in our constitutional arrangements, taking a very literal view on it, and others saying if you're do it in a certain way because the defendant is not yet charged, and so shouldn't be treated the same way.
But sir, on those, the various recommendations did engage the specifics of the pre-charge regime.
Did or did not?
Engaged it in the alternative.
Yes.
Right, so they said, we don't agree with it, but if you proceed, we recommend these measures to improve it.
So the policy of the law is that absconding is an offense. It's an offense that already exists. We're not creating a new offense, but we certainly treat breach of a condition of bail differently. We have not created additional offense for breaching bail. The consequence is simply that the bail would be revoked if you breach the condition of bail. But insofar as absconding bail it is an offense, and it is now an offense that is punishable with imprisonment, not a fine, in the scheme of things. So when we come back to consider a little more closely the recommendations around 5, we'll see what has been made. All right? But the policy, this recommendation for a fine goes against the policy, and I would say, let me hear from committee members, but it's not the policy. Part of the reform is to make the offense of absconding punishable with imprisonment. And on conviction, if you are convicted for the offense that you were on bail for, your sentence will run consecutively, and that is to let people know, don't abscond. Don't abscond. Yes. Because the courts know if matters are not tried in a timely way, we have numerous examples of the court revisiting those defendants and granting bail, even where initially a grant of bail would have been denied, taking into account the length of time that it has taken for trial. Any comments?
Madam Chair, I have strong views on the matter, but I will wait until we are looking back at Section 5.
You have strong views on the offense of absconding or absconding in relation to the pre-charge regime?
In relation to pre-charge bail.
I see.
But I will wait until we are discussing Section 5 again. Suffice it to say that I do not agree with Ms. Grant's approach. But I will wait until we are discussing Section 5 in detail.
All right. Okay. So we will defer the consideration, the accepting or rejecting the recommendations when we consider specifically the pre-charge provision. So we can move on. We will adjourn at around 12:45. So let's.
I'm not sure. Do we still have a quorum, Madam Chair? I can't recall a quorum for this committee. But I think so I've noticed that some of our members
Member Paulwell has stepped out. He's here in the chamber. He's here in the Parliament. He has moved from online.
Yes, I see.
Yes. All right. We go to...
Okay, Camille Golding. Section 14.2 could possibly include some reasons that would constitute reasonable excuse so as to avoid doubt, such as illness caused by physical or mental infirmity. Perhaps this could be the subject of further regulations regarding the bail bill. It is suggested that certain parameters be set within the interpretation section regarding especially section 14.2 of this section, as the use of reasonable may pose issues in terms of statutory interpretation.
Well, the term reasonable applies in so many provisions, and there is so much, there's nothing new to our laws at all. And what certainly is reasonable will depend on the circumstances, eh? Right.
I think reasonableness is usually expected for the court to use its discretion to determine.
Yes.
Clause 15. Liability to arrest for absconding, breaching conditions of bail, etc. Jamaicans for Justice. It is being proposed to amend Section 14 or Section 5. Oh, it's the same thing. Oh, this is an error. This is what we just discussed in relation to 14. It's the same thing. Yes, I think it's duplicated in error. So we move to the Jamaica Constabulary Force. Recommendations are being recommended. The following are being recommended.
Recommendations are being made?
Recommendations is the header. The following are being recommended. We recommend that an offense is created under section 15.2.3 for breach of bail conditions. We suggest that breaching bail conditions should be treated as an offense so that judges are given the option of not only revoking bail, but also allowing offenders to be penalized in circumstances where punishment is deemed to be necessary, but a revocation of bail may seem extreme. We suggest that for such an offense, a penalty of a fine not exceeding $1 million or imprisonment not exceeding 1 year be included. Rationale. Currently, many stakeholders in the court struggle with how to treat with a breach of bail conditions. This is because the current legislation only provides for the revocation of, I think that means bail, and readmittance to bail. And many judges do not wish to revoke bail as it is seen as excessive, but rather to penalize an offender for their disregard of a court order. Hold on, that's it. I'm sorry. That's the end of it from the Constabulary Force in relation to Clause 15.
You know, I think we have sufficient offenses all around the place. Further adding offenses must be carefully done. But let me hear from committee members. If we have no comments, then Norman, yes, proceed with
Norman Manley Law School, Section 5, which addresses the breach of any condition of the defendant's bail and provides for him to be arrested by a constable, kept in custody up to 48 hours before being taken before the court. That's 12.2a. Can result in a revocation of his bail and his being remanded in custody under 15.4. This is an intolerable encroachment on the rights of the pre-charged defendant. It is based on a failure to acknowledge his status as one who has not been charged with any offense. He's again been unfairly equated with a post-charge defendant. The Constitution did not contemplate and therefore cannot permit a person who has not been charged and may never be charged through a legislative device to be treated as what he's not, a defendant.
Any comment? All right, no comment, we move on.
Clause 16, bail with surety. Camille Golding. Recommendation. In relation to section 16.2 in the fourth schedule under the heading persons exempt from acting as a surety, the first listing is murder. It is perceived that that may be a mistake, or is it that it should have read one accused of murder?
Madam CPC, I think that was a printing error. It was a printing error, yes.
Yes. Okay. Accepted.
So for the record, Chair, we are accepting the
recommendation.
As a printing error?
Yes. It seemed that way.
Well, that's a convenient way to deal with the recommendation, yes.
Yeah. Okay. The Jamaica Constabulary Force recommendation, section 1610 creates an offense where a person in any declaration makes a statement which they know to be false. We recommend that this be expanded to capture instances where a statement, I assume it's maker, has no belief in the truth, but does not know for certain whether it is true or false. Reckless disregard as to whether the statement is true or a conscious effort to avoid learning the truth should be captured. This is so that the defendant is not relieved of a consequence of a material misrepresentation by lack of knowledge where the means of ascertaining truthfulness are available.
Just remind me of the section this weekend. I was momentarily distracted. Which section is it that they're commenting on?
We're at clause 16, and this is a reference to clause 1610.
Thank you.
What I understand the recommendation to be saying is that you may not be in a position to determine whether it's true or false, but you don't believe it to be true. Don't make such a statement. Or that you have a duty to inquire whether it is so or not. I think while I understand what the concern being raised, I think it's a real stretch. So the offense at 1610 is a person who, in any declaration required under this section, makes a statement which the person knows to be false in any material particular, commits an offense. So, Madam CPC, do we have the provision where they know to be false or does not believe to be true? I think we have that wording in some other place.
It might be, but I think this is the usual provision in respect of making false statements in declarations. I think it might be the matter of proof might be a little difficult in terms of the person's belief.
Yes. All right. Anyone?
Sure, the declaration falls under the Voluntary Declarations Act. Yeah. And whatever obtains for declarations under that act will govern. I don't think we need to do anything to this provision, in our view.
I'm similarly of that view. Yeah. Unless there is any other view, we can...
Yeah, because the form that's in the schedule specifically indicates that it is a declaration under the Voluntary Declarations Act.
So we wouldn't accept that one. Let's move on quickly.
Norman Manley Law School. Recommendation. The submission is that the bill should retain the provision where the only responsibility of the surety is to guarantee the court appearance of the defendant. It is submitted that when the responsibility of the surety remains, as is proposed in the bill, the distinction between surety and defendant are blurred, or is blurred. Rationale. While the provisions in section 16.1 to 3 are not contentious, the provisions at 16.4 that the surety shall have a duty to ensure that the defendant adheres to the condition of the defendant's bail, this condition and the consequences of its breach are far too onerous and may result in reducing the number of persons willing to volunteer to be sureties. The above is compounded by the fact that the only provision, which is in section 15D, where the surety can be released from his duties, is based solely on a single ground: the defendant is unlikely to surrender to custody. What then if the surety has reasonable grounds to believe the defendant will disobey the other conditions? He is trapped by his bond and will be penalized by any of the attached sanctions. He is required to sign a voluntary declaration that he will forfeit the sum of the defendant if the defendant breaches any condition of the recognizance. And this is in part 2, statutory declaration to be made by a surety. It's in the schedule. On the matter of inconsistency, the forms in the Recognizant and Sureties of the Peace Act, particularly the notice, require the surety only to guarantee the defendant's appearance at court. Forms 25A to B in the Justice of Peace Jurisdiction Act recognize only one condition of the defendant's bail for which a surety has responsibility: his appearance at court. Section 17.1 of the bill states that the sole purpose of being a surety is to guarantee attendance to court and is to keep with 17.1a. However, inconsistently, Section 17.1b then incorporates the breach of other conditions separate from just attendance. Under the present Act, Section 18.1 of the present Act also recognizes that the surety's only responsibility is to guarantee the defendant's attendance at court. Quote, where a surety has provided as security for the purpose of securing a person surrendered to custody and that person fails to surrender to custody, the court may order the forfeiture of the security. That's the extract from the present act. Furthermore, Section 6.5, even where it touches and concerns parental sureties of minors, it requires the consent of the parents to place supervisory responsibility for all or some of the conditions on the surety. Furthermore, there is a legislated cap on the sum that may be forfeited, that can be forfeited if there is a breach of the bail conditions.
Any comment?
Yes, Chair. I want to support the submissions which have been made. When we were discussing the idea of a parent being responsible beyond ensuring the attendance of the minor the child at court, I supported it because I think that the fact of it being a minor means that a parent has extended responsibilities if that person is before the court. But in regard to this section, I do agree that it should be confined only to the point of ensuring that the person turns up to court. We can't predict here now the nature of the conditions which might be imposed, because a judge will look at all the circumstances. For example, one of the conditions which I had imposed in a case that I was doing recently was that there should be absolutely no contact with the complainant or her family. And it would be a stretch to impose a duty on somebody who stands surety to ensure that that condition be observed by the accused man or woman. So I think if we think it through in a logical way, we can see the challenges that it would present to somebody who has stood surety. And we can understand that it would be, it could be a deterrent for persons to step forward and perform that very important obligation. So I really do think that we should pay very close attention to the submissions that have been made in this regard.
Yes. May I invite a response from the technical team?
I'd say it's a reasonable suggestion coming from the Norman Law School. And the example just made by Senator Scott Motley, I think, provides a cogent basis for its consideration. There may well be conditions that are unreasonable to be imposed on someone standing as surety, so that a blanket requirement might not be ideal in some circumstances. So it's definitely worth reconsidering the provision. I think when we discussed the matter of the last time we had the committee considered, words to the effect in relation to the police supervising curfews to say in the legislation that the court can prescribe circumstances in which or conditions in which that supervision could take place. Perhaps a similar approach could be taken here. But the point in relation to the provision itself I think is well put.
Madam CPC?
It's entirely a matter of policy, Chair. I have no view.
Yeah. All right. I do believe it is a reasonable submission. Outside of a surety, a parent standing surety for a child with consent, and that duty being placed on such a consenting parent, I think we wouldn't want to place a surety in a position where it's really impractical for him or her to discharge the duty. So, would it require modifying words? Generally speaking, what we want to encourage is that when you step beside someone who is in conflict with the law and you take responsibility for them, if we speak traditionally of ensuring that they surrender to custody, it's really to help as far as possible to ensure that they are not worse off and are not opening themselves to being worse off in the law. Madam CPC, how would a modification of that provision, what's your thinking on how it would be read if we were to consider?
What's being proposed is just to remove the requirements about ensuring the adherence to conditions of bail, but leaving the duty to surrender or appear in court where required. So,
amending this provision require amendment for any of the other provisions?
I think it's mostly in 16 itself, clause 16, and in clause 17(1)(b). So in clause 16, 3D, where it speaks about capacity to supervise the conduct of the defendant and to ensure the defendant's appearance in court where required, we would have to take out the reference to supervising the conduct of the defendant.
I think there was a special reason for this provision from a policy perspective, but the point is certainly taken about how the duty is cast or not, having a provision to ensure that if a surety has done all you can, then you wouldn't be in breach of that duty. I think I'd be more inclined without running afoul of the policy, because the requirement about the capacity to supervise was certainly included in that way, for that reason.
So, Madam Chair, if we were to consider Mr. Foreman's suggestion of having a similar provision about it being in accordance with the directions of the court,
yes,
then the supervision there could then be tied back to some words in accordance with if required, on any directions given by the court.
Yes. I think that probably would strike a reasonable compromise. Senator Scott Motley.
I suppose if it is thought that it is necessary to give that role to the surety, that would be a reasonable compromise. Yes. I'm not aware of what would be behind this policy, but I am assured by you that it is a policy,
yes,
part of the government's policy.
Yes.
So that at least would give some balance.
Yes, I think we can strike that compromise. So, so the recommendation would be partially accepted and the provision would be amended to provide that should the court so order, then it would come in that way. All right.
to be clear, Chair, that is only 16.4.
16.4,
not
yes.
17.
Let's see what is the recommendation in respect of 17?
It would be 16.3D as well. 16.3D is 16.4.
3D, 16.4,
and 17.
And 17. Those would be the related provisions that would have to be amended. So 16.
This thing with 17, though.
3D. 16.
17 is a discretion, where 4 was obligatory.
4.
4 was a duty. So you may not have to disturb 17 CPC. It's just a discretion that the court is being given. And if the duty is removed, I wouldn't see the court.
Yes, I think 17.
Yeah, I think once the duty is removed, 17 could remain, because then the basis, I don't think the court would.
I think the specific one was part of the was what was specifically objected to in the comments as well, because if the surety is being put up in order to guarantee the surrender to custody and not the adherence to the bail conditions, then how is it justified that then this surety could be forfeited based for the fact of a breach of
the condition?
A condition?
Okay.
Only where the
That's a very
surety,
important
that would
point.
be in respect of a surety for who consents to their parent. I think that would relate to that provision. So you may have to do some cross-referencing. I don't know. We can consider that. Right? Because there is that provision at 3. So I would say just check to see what tweak may be required at 17.1b in light of the changes to 16.3d and 16.4 and the provision at 3.2 or 3.3. Right. All right.
Clause 17 is without.
Right. So the clause 17 would only be considered along the line just stated. So we can go
to 18.
18.
Norma Manley Law School. Clause 18.1 B to D has made provision mostly for post-charge defendants. However, there is nothing relating to the pre-charge defendant with surety except for subsection 1A. The question is whether the period of 6 months has expired without extension. How would the surety know he is released from his obligation? Also, section 18.1c does not address what category of matters would be dismissed that do not fall under B or D. The provisions of section 18.2 also raise certain issues. 1. Limiting jurisdiction issue. Where there's a limitation of jurisdiction to the court having jurisdiction to try the offense and the attendant problems raised earlier in this submission. 2. Notice writing. It appears that the surety has to write 2 notices. One to the investigating officer, section 15.2b, and then to the court. Why is this required?
What is saying that 18.1 has made provision mostly for post-charge defendants. However, there is nothing relating to the pre-charge defendant except for 1C. Question is, where the period of 6 months has expired without extension, how would the surety know he has been released? You want to answer that for me, Madam CPC? Because the scheme is that if no charge is made and no extension is made, then a person can't be on pre-charge bail for longer time, because the time is really to enable the charges to be laid, enable what needs to be done to convert what would have provided for reasonable suspicion that engaged the right in the first place to get to. And if you get to the time and you do not use the time, then the defendant would have to be released thereafter. And if you are released unconditionally, then anything else that flows wouldn't stand. But we just want to make sure that there is no ambiguity around that. Maybe we could defer that until we come to the closer consideration of 5? Madam CPC, you think? Yes. All right, so let's move quickly. It looks like we could finish all of the provisions and just leave 5 for the next meeting if we're at 90 now.
Chair, there was just, and I have a note here, it's not in the matrix, but that the constabulary force had indicated that they preferred the general language of section 19 of the Act. It is, I think it's in relation to 18(1)(b).
Yes.
Because a nullity may not end the matter.
So my note here is which type of nullity, because it could be a nullity prosecuted to commence de novo.
Right, so yes. they had raised an issue with that.
Yes, for proper consideration, yes.
Okay.
All right, so it looks like we could finish the other clauses before 1 o'clock. That was my time limit, not to go beyond. I did say 12:45, but if we can take it up to that, then it would just leave us with the pre-clause, pre-bail regime to come back to and try to deal with on
we have the
Friday.
schedules, though.
Yes, we had gone through the schedule, if you recall.
We did?
Yes, that's my note. But that's always, we'll still have to look on the offense of Section 21 under the Zozo law there. And we have to look at the forms, yes. Yes. So let's try take it up to the end of the clauses.
Clause 19, Jamaica Constabulary Force. We recommend that the provisions of Section 19(3)(b) of the current Act be retained as a provision of the proposed bill in treating with circumstances as the case may be. Section 19(3)(b) states, where a surety is released, the defendant concerned, oh dear, sorry, confused.
Shall forthwith be notified of such release.
Yes.
And B may be taken into custody until he provides other surety or sureties.
Yes. Rationale. The provision of Section 18(2) of the bill do not address the status of the defendant where the surety is released from their obligation under Section 18(1)(a) or where a nullity prosecution is entered under Section 18(1)(b). In order for the matter against the defendant to be discontinued in the parish court and commence de novo in the Supreme Court.
Yes. To be considered. I'll just ask the CPC to consider.
I think we had agreed to
accept
make
it?
the change.
Yes. All right. So we can accept. Any comment? If no comment from other committee members, we can go to 20.
No, Norma Manley Law School.
I see.
It is submitted that Section 19(1) creates a substantive offense. An essential element of that offense is that the person is a surety. It then appears internally inconsistent that 19(2) reverses what 19(1) already states is an element of the offense.
What is that? No person shall indemnify or offer or agree to indemnify a surety against the possibility of loss arising from absconding. And what they're saying is reversed to?
Into
an offense under the section may be committed. An offense under the section may be committed whether the offense or agreement is made before or after the person. Which part of 1? Can you, can...
Because 1 says no person shall indemnify.
Yes.
And 2 is making provision for the indemnification.
Is it how it is provided for, Madam CPC?
I wasn't following.
Yes.
Okay, just repeat.
The submission is that 19.1 creates the offense. Prohibiting indemnification, offer, or agreement to indemnify. That's the offense. And then they're saying an essential element of the offense is that the person is a surety. And then 2, an offense on the 1 may be committed whether the offer or agreement is made before or after the person to indemnify becomes a surety.
Well, the totality of 2A to C, I think, clarifies the situation because the nature of the offense is that the agreement might have the effect of discouraging that person from becoming a surety. That's why 2 provides what it does in A to C. So it has to be construed that the offense would apply even though the person didn't become a surety.
I think we may have to just look at the wording of 1. Right, because if you... It's really the surety or... I think we may just have to look back on the wording of it. All right? So let's revisit the wording in light of what is raised by the Norman.
We could, instead of talking about a surety, I
Yes.
suppose, we could talk about another person.
Another person. That's what I was thinking. Yes. All right. So so the recommendation is, well, the recommendation is not recommending, but the submission is favorably considered, is the way I would put it, because it doesn't. So we're just checking the internal consistency of the clauses. All right, submission, the recommendation to check the internal consistency of the clauses is accepted. All right. And possibly changing surety to another person. All right, good. Let's move over to 20.
Yeah,
20?
Chair.
Yes?
We're just consulting. It is consistent with what is in another jurisdiction, but I think the principle is the agreement to identify is in itself an offense.
So we know what we're seeking to achieve. We just want to ensure that the way it is provided for is clear. And I kind of see it's more a pedantic approach, but different people read the law. The law is not just read by practitioners. They're also read by teachers of the law.
Right, so, yes.
Well, the point is to just check it to see if there is any inconsistency.
And I'm saying I don't think there is. I think it may be, I don't know if the way it is set out could make it clearer. I don't know. But the point is whether you actually indemnify or you agree to indemnify, you have committed an offense. That is the...
yes. All right. I see there is nothing for 20, 21, and 22.
Yes,
24. Or 23, so 24.
Goes to 24.
Right.
And this is the Jamaica Constabulary Force. In Section 24 of the Act, which makes consequential amendments to other enactments, we ask that the Corrections Act be amended in Section 210 so that the definition of correctional institution can include a place of detention as well as lockups. As it currently stands, lockups and places of detention are not included in the definition of correctional institution under the Corrections Act, which has resulted in the police not being empowered to charge where knives, marijuana, and other material are found in these places.
So this matter, the review of the Corrections Act is underway. And I think this very matter has been raised in another forum. And I realize that there are different administrative arrangements around the places, but I will invite a committee member who is a Minister of National Security for a response on this.
Yes, I believe that it's a broader issue.
Yes.
That the constabulary force themselves have raised in relation to their capacity.
Yes.
Broadly to deal with lockups. So it's an issue that goes beyond this bill.
Yes. Well, on that note, all right, we still have about 10 minutes. You think we can push it? Or we take the break now? Take the break now? Or all right. So I am reporting very good progress. So the only thing that we would be left with are those matters that we have deferred. But generally, it's just a pre-charge regime and the schedules that we would have left for review. So I would say now all provisions, clause by clause, up to 24. Up to 24. Done. And then we are to return to clause 5 and the schedules, as well as any specific matter deferred. So hopefully we can conclude our deliberations in our next meeting, whole day meeting on Thursday. Is there any other business that any committee member wishes to raise? All right, if there is none, may I just ask the technical team to track the matters? I know Madam CPC is tracking. And then the date and time of the next meeting is Thursday the 30th, at 10 a.m. And we hope to conclude our deliberations, not the last meeting of the committee, because we have the report that we will have to deal with. Let me thank all members and the supporting teams for your kind assistance. I am reporting progress. Any last opportunity for a last word from anyone else? Right, if there is none, may someone move for the adjournment? Member Charles at 12:55, seconded by Member Scott Motley. Meeting is hereby adjourned. I'm doing
Let us resolve our family disputes peacefully. A family is a circle of love, support, and strength. Violence has no place.
The proceeding was brought to you by the Office of the Prime Minister.
I must urge all users of cyberspace, do not, for fear of being labeled a victim, refuse to report or follow through the process. Once you think that there is something wrong, seek advice, and the easiest way to get that advice is to come to Jamaica Cert or to go to the nearest police station. You will not be looked down upon for being a victim of cybercrime, because it is a matter of when for us all, not if.
To report a cybercrime, call or visit the website of the Jamaica Cyber Incident Response Team or make a report to your nearest police station.
Whenever you hear the following tone, the Office of Disaster Preparedness and Emergency Management, ODPEM, will be giving information on an emergency situation affecting the island. Please be on the alert and listen to your radio and television for further information. This was a test of the emergency alert system, brought to you by ODPEM.
Jamaicans, look on the murder rate. You think that normal? We need to get every illegal gun and save our country.
The proceeding was brought to you by the Office of the Prime Minister.
How many more must die because of reckless drivers? How fast is too fast? Make we take time, no man. Obey the rules of the road. Drive with care.
Classmate could be a future lawyer or minister.
Do you know that your classmate or your schoolmate could be a future prime minister?
So here what? Just make daddy proud. Not have me a worry.
Don't fight or lash out. Violence is never the answer.
Before you pick up a stone,
why not pick up your book and just meds it? We all have our part to play.
Let's end violence.
Let's end violence. Let's end violence.
Let's end violence. Let's end violence.
Let's end violence.
We must end violence in schools now.
Girls, how are you? I trust that you are doing fine and ready to learn. Welcome, welcome, welcome to our language grammar session, grade 2. Today's objectives: recall the definition of nouns, correctly explain the terms singular and plural, explain the formation of plural nouns, accurately define nouns that form their plural by adding es from a list of nouns, correctly apply the rule of adding es to make singular nouns plural, and work cooperatively in groups to accurately form the plurals of given singular nouns. Here we go now down the road.
Nouns. Everything around us has a name. People, animal, places, and things have names that we call nouns. Nouns are also called naming words. Mother, father, cow, pig, table, book, school, are all naming words or nouns. What are you sitting on? Are you sitting on a chair? Say the word chair out loud. This is its name or naming word. It cannot eat and drink or move. It has no life. It is a thing. Whenever you read the word chair, you see a picture of a chair in front of your eyes. You also know that you use the chair when you want to sit. What things can you see around you? Call out their names. These names of the things around you are their naming words. There are many people who help us. A teacher helps you study in school. Say the word teacher. Whenever you read this word, you know that it is the naming word for the person who helps you study in school. Think about the people who help you every day and those who help you sometimes. Which animals have you seen? Have you seen a cat or a dog? These are the naming words for animals. When you read the word cat, you know what kind of animal it is. Think about the animals that you see in a zoo. The names of the animals that you see are their naming words or nouns. Where do you go to study? Yes, you go to school to study. School is a naming word for a place. Which city do you live in? The name of that city is its naming word or noun. Can you think of more places? The names of all these places are called nouns.